Good morning, ladies and gentlemen of the jury. And of course, let me remind you, the trial continues. Don't form any definite or fixed opinion about what we're doing at this time until you've heard all of the evidence, the arguments by the attorneys, and the instructions on the law by me. Also, make sure to confine your decision in this case to the proper evidence and nothing else, so don't speak to anyone, including your fellow jurors, about the case until you begin to deliberate, of course, with regard to your fellow jurors. We continue on with the defense mitigation case, and Mr. Burns, you may call your next witness.
Thank you, Judge. May we have Ms. Carrie Schwartz to the witness chair?
Ladies and gentlemen, Mr. Burns has advised me he intends to read a deposition. Is that correct, Mr.
It is. It is a transcript of a deposition, Your Honor.
And this person is not the deponent. This person is just being used to facilitate the presentation of the evidence to you. So she does not need to be sworn as a witness at this time. She's being used as a conduit. If you remember in the guilt phase of the trial, it's the same procedure the state used with regard to their conduit witness, just to put the evidence before you. And Mr. Burns, if you want to explain to the jury what the item is.
Thank you, Judge. You're right. A couple of months ago, a lady that we of the defense had hoped to use as a witness came and gave a deposition. The way it works in Florida, if the state lists witnesses, we get to ask them questions. It's a deposition. And when we of the defense list witnesses, the state gets to ask them questions. So there's no trial by ambush or anything in Florida. And in a deposition, the witnesses are sworn to answer truthfully. So this is a lady who came in. Her name is Madeline Colon. She spoke and gave this deposition under oath on July 7th, 2025. And with the agreement of the state, we're going to, and following the methodology that they used earlier in their case in chief, we're going to read it to you. I will be playing the part of Mr. Richardson, who was asking the questions. I feel like I should borrow his white hair for this role. But I will be playing the part of Mr. Richardson, and Ms. Schwartz here, who is my mitigation specialist in the case, will be reading Ms. Colon's words. Okay? Are you ready, Ms. Schwartz?
I'm ready.
All right, we're on page 3, gentlemen. Go ahead and state your name for the record, please.
Madeline Cologne.
Okay, and a few background questions. Have you ever been arrested before?
Yes.
Okay, for what?
Driving on a suspended license.
Okay, what county was that in?
That was here when I moved. I want to say probably 2007, 2008.
Okay, and I assume that was a misdemeanor?
Yes.
Okay, and were you convicted?
I had to do probation.
Okay, gotcha. Any other arrests?
No.
Have you ever been convicted of a felony?
No.
Have you ever been convicted of a crime of dishonesty, such as theft or worthless checks or things of that nature?
Hold on. I think it was also when I moved here, like an $11 check from Publix, but that was a long time ago.
Okay, was that in St. Lucie County?
Yes.
Okay, do you recall what happened to that?
No. They stated that I had insufficient funds in my account. It was like $11 and some change. That's how I found out, because I got arrested on Halloween night. I was on the passenger side and the driver pulled over because I was sick, and they took me to jail, and not the driver, because they said I had a warrant out for my arrest for an $11 check, which I didn't remember.
Okay.
But that was like when I first moved here.
Okay. And how do you know Jose Soto-Escalera?
He's the father of my child.
Okay, and when did you first meet him?
I moved here 2007. I probably met him the same year that I moved here, because I had Antonio. About the end of 2007, beginning of 2008.
Okay, you said several times you moved here to Florida. Where did you move from?
Michigan, Detroit.
Detroit, Michigan?
Uh-huh.
Okay, and how did you meet Jose?
Social media.
Okay.
MySpace.
On MySpace?
Uh-huh.
So the days before Facebook?
Correct. That's when I found out. I'm like, oh, what was his name? Tom? I'm like, he owes me child support.
Okay, gotcha. And you never married Jose?
No.
You were never married to him?
No.
But you did have a child?
Correct.
What is the child's name?
Antonio Escalera.
Okay, and what is his date of birth?
10/20/08.
Okay, and how long were you in a relationship with Jose Soto-Escalera?
It wasn't long in the beginning because I moved here in 2007. We met, I ended up pregnant, we moved in November.
Moved in together in November?
Moved in together in November
Okay.
of 2007. And then we split up after I found out I was pregnant because he was in another relationship with somebody else. I was the rebound girl and I didn't know.
Okay.
Uh-huh.
So how many months would you say you were in a romantic relationship with Jose Soto-Escalera?
I came here before July 4 because it was my birthday, September. So probably July, August, September, October, like 4 or 5 months.
Okay.
Uh-huh.
Did you maintain a relationship with Jose Soto-Escalera after you had your child Antonio?
As in romantically, we did try to make it work for about a year, and then we split up again because we figured it was better off us being friends.
Okay.
Because Jose kept me and the other girl.
And you're motioning with your hands. Do you mean he was having
Back and forth.
relationships with other women?
Myself and the other girl he was with before I found out.
Okay, gotcha. And after the romantic relationship was completely severed,
Uh-huh.
did you maintain any kind of relationship with Jose?
Yes, yes.
Okay.
We're friends.
Okay, so you were still his friend?
Absolutely.
Okay, and did he pay you child support?
No, he didn't have to. We had an agreement that he would take Antonio. When he would drop him off on Sundays, he would bring groceries, school supplies when it was time for school. I would get him his shoes because I'm very picky about the sneakers. He would get him clothes and supplies. And then him and his wife would pay for the Boys and Girls Club.
Okay, and did Jose actually honor that agreement?
Yeah,
He did.
yeah.
So Jose does not owe you any additional money?
No, I don't. I mean, you have a responsibility, you know, we made a kid together. This is what you do, this is what I do.
Okay, gotcha. And what do you do for a living?
I'm a receptionist. I work at a doctor's office.
At a doctor's office?
Uh-huh.
Okay, great. During the entire length of your relationship with Jose Soto-Escalera, has he ever been violent with you?
No, he actually helped me out because I came from Michigan because of a domestic violence situation with my older 2 children. I sent my older son here with my mom, and then the last straw for me was when their father broke into my 2nd-story home. I thought I was going to be dead, so I took my younger son, my middle child, and moved over here to Florida.
Okay.
And then I met him. That's why, I don't know, it was just fast. But he showed my 2nd son how to ride a bike. My 2nd son says that's his father, and then I ended up pregnant with Antonio.
Okay, and you said Jose helped you following the domestic violence?
He made me feel secure, made sure that I was okay being in another relationship because I was with my first kid's father for like almost 10 years.
Okay, and how exactly did he help you feel secure?
How do we say? We have setbacks like PTSD. I've had a lot of triggering moments, as in if I see an argument, like if we're having a conversation and it gets a little bit heated and you're confronting me, that makes me pull back because of the situation that I was in before. And he just never made me feel like I needed to be worried about going into another room or going to spend the night at my mom's house. I was never scared. Even I'm a little hot-headed, so I would be the aggressive one and I would start things and he would just leave and then come back.
Okay. It sounds like you guys had a fairly deep relationship. Is that fair to say?
We did. I mean, coming from where I came from to then coming here to meeting him is completely different. Living in Detroit, coming to Florida is just like, wow, you know, the people are different, the atmosphere, the way you dress, the way you talk, family-wise. It was just, everything was there. Him and his family, me and my kids, they invited us everywhere and never was like worried about leaving my kids with him. It was never that feeling.
Would you say you had a close relationship with Jose?
Yes.
Okay.
I think we still do.
Still do?
Uh-huh.
Okay. Meaning that you would talk about things that perhaps you would not talk about with an acquaintance or simply a friend?
Correct, because I would feel he would never judge me.
Okay, so Jose was non-judgmental.
No.
And you would share things with him on an emotional level that you would not necessarily share with somebody else?
Correct.
Okay, and did that street run both ways? Did Jose share things with you?
I thought he did until I found out that I was the second girl.
Okay.
And I was not the main one. But he was very good with it, you know. He would say that because he was security, so he would work during the day, and then he did security at the bars at night. So that made me feel like, okay, he's doing his work. He needs to come home because he needs to make sure everybody is home after 2 o'clock, after 3 o'clock when they close the bars.
Okay. Did Jose ever share anything with you regarding his childhood, the way he was brought up, anything of that nature?
I do not know about him when his first children's mother got together in Connecticut. He told me about that story.
Tell me about that.
How they moved over here. They were young. She was a little bit older than him, so he was kind of like in the streets being a rebel, not going to school. And then his mom didn't force him to go to school. He met some Hispanic family, which they call themselves brothers now. They all moved over here together when Araceli was pregnant with their first child.
Okay, you said the name of a woman. Can you repeat that?
Araceli.
How do you spell that?
Araceli, I don't know. I know her last name is Lopez. That would be his first children's mother.
His first child's mother's name is Araceli Lopez.
Correct.
And how old was Jose when he fathered that child, if you know?
I believe, if I'm not mistaken, 16, I think, around there.
Okay, have you ever met that child?
Yes.
What is that child's name?
Jose.
Jose Soto-Escalera Jr.?
I don't know if he has the Soto-Escalera because after a certain amount of years they found out that he was not his child.
They found out that...
Araceli told Jose after, I think 18 or 19 years old, she called Jose and Jose Jr. and had a sit down and told them, hey, by the way, he's not yours, but Damien is. So I feel like if he was about to snap on anybody at that moment, he should have, because that's, excuse my language, pretty shitty. But if she wasn't certain as well, maybe that's probably why it was never brought up.
Okay, so let me just fill in some blanks. The person who told Jose...
Is the mother.
Okay, just to be clear, so Miss Enlow here is taking down everything that we say.
Oh, okay.
So I know it's hard to, we don't have conversations like this normally, but
Uh-huh.
if you could just wait until I finish my question before you answer, I'd appreciate that.
Okay.
It just makes her job easier.
No problem.
So the person who told Jose that Jose Jr. is not Jose Sr.'s father is, what is her name?
Araceli Lopez.
Lopez?
Lopez, uh-huh.
Okay, gotcha. And you also mentioned the name Damien.
That's their second child. Jose has 4 children.
So Damien, and what's Damien's last name?
Escalera.
Okay, and Damien is the son of Araceli.
Lopez, correct.
Okay, and so what you're saying is that Damien is the biological child of Jose Soto-Escalera.
Yes.
Okay, and the source of your information for this story
Uh-huh.
is Jose Soto-Escalera.
Yes.
He told you that.
Yes.
Okay. Have you spoken to Araceli?
Yes.
Okay, did she give you the same account?
Yes.
Okay, have you spoken to Damien?
Yes.
Okay, does Damien give you the same account?
It was conversated once. They're really kind of private with themselves, so it's not something that we just bring up. But it was known once everybody found out, and that was left alone.
Okay.
But Jose still treated Jose Jr. as his own.
As far as you know, did Jose Soto-Escalera treat Damien well?
Yes.
Okay, how do you know that?
Because we were together when they would come over. And his third child, which is Joel Maldonado, he would also come over. He's with a different mother.
Okay.
They would come to my house. Araceli would leave the kids over. But the older 2 were able to travel themselves because they are older children. So they would come to my house without their mother or without Jose being there. They would just come over.
Okay. Have you ever seen Jose Soto-Escalera treat any of his children with anything other than respect?
No.
Okay, he's been a good father,
Correct.
as far as you can tell.
From my understanding, the first 3 he did pay child support for. The only one was my child because I didn't feel like there was a need because I saw how he took care of his other children. Clothes, shoes, haircuts, whatever they needed, Jose was there.
So obviously, if Jose Soto-Escalera is having this conversation with you and he's telling you these intimate details of his life,
Yes,
did he trust you?
absolutely, because he cried, and he's not much of a crier. He was hurt.
I understand.
Uh-huh.
Okay, let me ask you this. Has Jose Soto-Escalera ever told you anything about being abused as a child?
No,
Okay, as far as you know, was Jose Soto-Escalera ever abused as a child?
no,
Okay, same question for being sexually molested. Has Jose Soto-Escalera ever told you anything about being sexually molested?
no,
Okay, do you know anything about that?
no.
Okay, and I'm not suggesting he was.
Oh, okay. I'm like, what? Oh my God.
No, I'm not suggesting he was. I'm trying to find out if he was.
Okay, phew.
Yeah. So let me ask you this. Did Jose Soto-Escalera ever reveal anything to you about his biological father?
He told me that he moved to Puerto Rico. He really didn't have much of a relationship with him. He told me that he was pretty tall because we were trying to figure out how our son is taller than the other ones. And Jose is not that tall for me. I don't think he is. He's pretty average of a man height. But he's like, oh, he should get that from my father because he's, I think, over 6 foot or something. That's pretty much the base that we've spoken on his dad. I've never met his mother either.
Okay. Did Jose reveal anything else to you about his life that was upsetting to him, Jose?
Besides that, he really didn't have much of a communication with his dad. No, not really.
Okay, was Jose ever involved in any kind of street gangs or anything while he lived in Connecticut?
That I don't know.
You don't know?
Uh-huh.
Did you still maintain a relationship with Jose in August of 2018?
Yes, absolutely.
When was the last time prior to that date that you had an in-person conversation with Jose Soto-Escalera?
We would see each other every week because he would pick up Antonio every weekend.
Okay, he saw him on the weekend.
Uh-huh.
Okay.
It was either Friday. If he was not there to pick him up, it would be Debbie. But he would make sure that he was there on Sundays because he would bring the groceries to my house.
Okay, but you would see him on the weekends.
Uh-huh.
Is that a yes?
Yes.
Okay, did you ever see him on like a Thursday night?
Sometimes. It depended if my son wanted to go and see his dad, because we remained friends, and I honestly thought me and his ex-wife were cool too. Like, I didn't have any bad vibes or anything towards anybody. So whenever they said, hey, I want to see Antonio, can we meet up or can you bring him by? Antonio was asking me to see his dad. I'll call them. If they're home, I will take him. It can be any day of the week, but mostly I would see him like either Friday or Sunday when it was like pick up or drop off.
Okay.
Or if I had to pick up a check from them for the Boys and Girls Club that they couldn't drop it off, I would swing by their house and they would give it to me and I would give it to them.
Okay. Have you ever seen Jose was he ever violent with anybody
No.
that you saw?
The most I've seen was somebody that he had to like manhandle to get out of the club because they were about to fight.
Okay, can you tell me about that?
Just to break up a fight. You know how the security have to grab you by your arms to drag you out and then leave them out, and that's it.
Where was this? You said it was at a club?
It's I'm trying to remember because the club is not open anymore. But you know the turnaround by Jensen, where you go to Jensen Beach, you're going over the bridge, you can go right towards Stewart. I think it is, but it has a CVS. I'm trying to remember the name of that place. I believe it's a restaurant now, Copacabana. I think that's what it was called. Yes, he was security there.
Jose worked as security there?
Correct. Uh-huh.
Okay.
I'm pretty sure that's what it was called, was Copacabana.
And about when did Jose break up that fight? What year? 2018, 2015, 2016?
No, that's when him and I were dating, so like 2011, 2012.
Okay.
Yes, That was back then,
But that
when him and I were dating.
was about the only time that you've ever seen.
Because on Thursdays we used to go to bike night. He used to ride motorcycles. We had our own little, like friends, like our little friend group. We would meet Jetty, Luris, home.
You've never seen Jose be violent. Is that no?
That's a no.
Okay.
Listen, I burned his clothes.
What do you mean by that?
I had a moment. After I had Antonio, he was still with the other girl. I found out, so I took Antonio out of the crib, put him in Jose's truck because Jose had a brand new F-150. It was red 4-door. He had a very nice motorcycle. It was a Thursday and he was out and about, so I found out where the girl lived. I went by her house. I called him because I saw his motorcycle there. They came out. I was the aggressive one. He kind of like picked me up and threw me in the truck, and he was like, "You can't do this here. You're not in Michigan. You're in Florida." So I went and made a U-turn. I friggin' broke her mailbox, went home, parked his truck. Went inside the house, took the baby, put him in the crib, grabbed all his belongings, went outside. I keyed his truck. I burned his clothes.
Okay.
I gave him like 3 or 4 flat tires. I almost busted all his windows. I called his sister and she's like, "Don't do it, Maddie." But I didn't bust his windows. But I only did,
Okay.
And he didn't, like when he came, he didn't park his motorcycle at home because his motorcycle was his prized possession. It was really nice. So he left it in the middle of the street, and he's like, "What are you doing?" And I'm like, "Going crazy." And he's like, "They're gonna call the cops on us." And I'm like, "I don't fucking care." So and I even took his phone. He was talking to his sister to come pick him up. I even took his phone out of his hand and I broke it in half, and he still didn't even.
Still didn't what?
No, he didn't put his hands on me. He was just trying to calm me down. He's like, "I'm so sorry." And I'm like, "No, this is when I told you exactly what I was going through and you put me through the same situation and maybe even worse."
Okay, and did the police ever get called?
They did not, thank God, because I was not trying to go to jail with an infant and 2 children at home. It was just a stupid reaction.
Okay. Is there anything else that you can tell me about Jose Soto-Escalera that would assist the court system in figuring out this case?
I honestly feel that he should have been honest on having a relationship with Tania or having a sexual relationship with her, because it's nothing new that he's always had 2 women in his life, and one of the 2 was always pregnant. It was like a pattern from my understanding. First baby mama, then to second baby mama, and then to me. So he's always had 2 women. So what was the difference in this case? Because you married somebody else, which was older than you? I don't know. It's just weird to me, that's all.
And we will conclude there. Thank you.
All right, and the defense next witness or item of evidence.
Judge, may we have Joanne Stone summoned from the hallway?
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And you may inquire of the witness.
Thank you, Judge. Good morning. You see that microphone right in front of you?
I do.
Sit real close to it. Tell us who you are, ma'am.
Hi, I'm Joanne Stone. I am the cousin to Jose Escalera.
Where do you live, Joanne Stone?
I live in Bridgeport, Connecticut.
How long have you lived there?
My entire life, 41 years.
And you said that you are Jose's cousin.
I am.
How well would you characterize that you know him?
Well, Jose and the rest of us were all brought up together. So we're all like brothers and sisters.
The purpose of your testimony is to help the jury learn something about Jose's character.
Right.
What can you tell us about his character? Have you ever seen him to be violent?
He was never violent. He was always humble, very quiet, and he was the fixer. He fixed everything with us. If the girls, there was more girls than there was boys. So the girls argued a lot. Jose would fix it. Jose never showed signs of any anger at all. And he actually left Connecticut because it was becoming very, very violent.
Well, that was going to be one of my questions, too. What type of neighborhood did Jose grow up in? Was it violent?
We grew up in a very terrible neighborhood. We lived really up the street from one of the world's worst projects, which was Father Panic Village. And in the 90s, the crime rate had went up, and it went up massively, more so in the 2000 era, and it's actually worse today.
Usually, high crime areas go hand in hand with low income. Were you rich, wealthy people?
We were not.
Were you on any government assistance of any sort?
Not that I know of.
What type of work was done by the breadwinners in the family?
Our grandmother was a cook. Jose's dad was a bus driver. His mom was a stay-at-home mom.
A school bus or a city bus?
City bus driver.
And how much schooling did Jose have? Did he graduate high school, if you know?
Well, Jose left at around 16 years of age, so no, he did not graduate high school.
He left for where?
Florida, to live.
Did he stay in touch with you?
He stayed in touch with the entire family.
When you mentioned that he would sort of act as a mediator, a peacekeeper among squabbling sisters and cousins, correct?
Right.
Would you characterize Jose as having been a positive influence on you or other family members when he was with you in Connecticut?
Yes. He ended up having a baby, and his decision was to leave and have a better life for his baby. Him and his son's mother left together. I believe she was a little older than he was, if I can remember. I am one of the smaller ones in the family, but I do remember them all really well. And they came here to start a great life, and he did exactly that.
Have you stayed in touch with Jose during these 7 years while he's been in our county jail?
I have not stayed in touch with Jose. He contacts, whoever he speaks to in the family. I hear about anything through my eldest aunt, but I have not. I've been going through my own personal stuff with my children and grandchild.
Okay, but you follow along vicariously through other family members.
Yeah, through the great aunt.
This is the jury who will be making a weighty recommendation to the judge about what should happen to Jose, and the choices are he should be sentenced to death or he should be sentenced to life without parole in Florida prison. What is your position?
Objection? I'll sustain the objection.
Is there anything else that you would like the jury to bear in mind while they make their decision?
Yes, I would like the jury to have mercy over him because you guys made your decision, and I respect your decision. But he's not.
Jury should disregard the answer to the question. Objection sustained.
If you have anything that you would like the jury to consider that doesn't have to do with them exercising mercy, anything you would like them to know about Jose's character?
Well, Jose is a good person. We all went to church. We came from a terrible background, but we all stood together whole as a family. He's a good dad. He's a good friend. He's a good relative. And I just don't know him for this.
Thank you. You have traveled down here from Connecticut to deliver this testimony, yes?
I have.
Thank you very much. That's all I have for you.
Thank you.
Yes. Okay, so I just want to put a finer point on some of the things that you discussed just now, okay?
Yes.
I believe you said that you knew Jose
essentially all his life,
all his life.
right? And you're related how?
I'm his cousin.
You're his cousin. Okay. And you lived very close to Jose when he was growing up as a small child, correct?
Yes, we all lived in an apartment building.
Right. So you're familiar with him.
Right.
Okay.
He taught me how to ride a bicycle,
Mm-hmm.
and like a really big bike. He taught us everything that we needed to know. He taught us how to be like handy girls, how to use a hammer. He taught us basically what we didn't have a brother, so he was our brother.
Sure. And when you grew up, you had a considerable number of family members around you when
Yes.
he grew up, right?
Right.
Meaning that he was exposed to those family members as well.
Yes, at all times.
Okay. So, and you're familiar with all those folks
Yes,
who lived with him.
yes,
Okay. So you know that the defendant, first of all, he was never sexually molested, right?
I do know that.
Okay. He was never physically abused, correct?
No, he was not.
Okay. And in fact, you even said that not only was he never emotionally abused,
No,
right? I think you told me out in the hall that nobody had ever even yelled at him when he was a child.
no,
Is that right?
right.
Okay. Okay. And to put a finer point onto your relationship with him since he moved to Florida, okay? So
Right.
let's focus in on that. He moved to Florida when he was 16 years old.
Right.
Around 1993.
Right.
Okay. And you would have not, you did not see him physically in person between 1993 and 2018, but just a handful of times,
Right.
if ever.
No, he came a few times
Okay.
to Connecticut, and he stopped to visit us. There was times. There was a time I heard he was there. I was down in Jamaica, burying a relative. So there's times where I missed it, but he came and I heard about it.
Okay. Okay. But your best estimate would be probably less than 5 times. Is that fair to say?
Right.
Between 93 and 2018.
Right.
Okay. And you haven't had any contact with him, I think you said on direct examination,
Right.
for the last 7 years since he's been incarcerated. Is that
Right.
right? Okay. All right. Thank you, ma'am. I have no further questions.
Thank you.
No, thank you so much, man.
Thank you.
Thank you. You may step down from the witness stand. And the defense next witness or piece of evidence.
May we have Taisha Hernandez called to the stand?
Before we call this witness, we'd ask her approach.
Sure.
Taisha Hernandez.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right. You may inquire of the witness.
Okay, speak right, nice and loud right into that microphone. Tell us who you are.
My name is Taisha Hernandez.
How do you spell your name?
Taisha.
And Hernandez Standard.
Yes.
You see Jose?
Yes, I do.
How do you know him?
That's my cousin.
Speak up nice and loud.
That's my cousin.
He's your cousin. Did you and he live together or very near each other in Connecticut?
Yeah, we all lived in a building, all our family members together in one building. Like, basically, we all left doors open, so it's like we all lived together.
Are you Jose's older, or I think you're younger cousin?
I'm the
right?
youngest cousin, yes. One of the youngest cousins.
Regarding Bridgeport and your particular neighborhood in it, was it nice? Was it criminal? Was it violent? You tell us.
It's not a place you want to raise your family in, so it's not nice, or it's what you make it.
And Jose, as a teenager, left the area
Yes,
to come here to Florida?
live a better life.
You approve that decision?
Yes, I would too. It was everybody's plan. It's always been our family's plan to get out of Connecticut and come this way. You know, so I'm a mom, so raising our kids is like, yeah, I'm gonna move here and this is where I'm gonna raise my kids to give them a better life and everything else. But, we're stubborn and life doesn't work for us that way as fast. But he's always want to help me. I can move in with them. They'll help me find a job, put the kids in a better school system and stuff like that. He's always caring, always put other people first before him.
When Jose came down here, he worked?
Yes,
And you just told us, I think, even though I don't think you maybe were able to carry through on it, Jose encouraged you and other family members to
to
follow.
help, always help, yep. He was our support system if we come, until we got on our feet.
He encouraged you to a better life.
Yes, always.
Have you observed Jose at any point to be violent?
Never.
Have you observed Jose at any point to exhibit kindness or generosity?
He's always kindness. He would put somebody else first before him. That's how nice he is.
We heard some testimony that some of the female cousins of Jose's might squabble and disagree among each other. How would Jose handle that?
He doesn't like us to be fighting. That's one thing. We're family oriented. We're supposed to be there for each other.
While Jose's been in jail here in Florida on this charge, have you stayed in touch with him?
Yes, I have.
Nice and loud.
Yes, I have.
How?
By phone.
Have you put any money on his canteen account?
No, his mom and my aunt,
What's his mom's name?
Carmen Escalera.
Was Jose able to finish out and obtain a high school diploma, do you know?
I don't think so.
Did Jose grow up in wealth and affluence, or did he not have money?
No, we all struggle. He wasn't raised that way with money.
Is there anything that you would like the jurors here to carry in their minds regarding Jose's character when they figure out what to do here?
Jose is a very loving, kind guy. I mean, I respect the decision you guys made, but that's not the Jose I know. And like I said, he loved his kids, loved his family. He always put us first before anything else, and he's over-caring. Respectfully, even talking to him from jail, he's always positive and still guides me to today to do better.
Thank you.
Thank
Thank you
you.
for coming. That's all the questions I have for you. The state may have some questions.
Cross-examination?
No questions.
All right. You may step down. Thank you, Mr. Hernandez. And the defense next witness or item of evidence.
Judge, if we could have Monica Ropiza. Monica Ropiza.
face the clerk, raise your right hand.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you.
And you may inquire of the witness.
Thank you, Your Honor. Sit real close to that microphone you see in front of you there and talk up loud. Tell us who you are, ma'am.
I'm Monica Ropiza,
And how do you spell your last name, Monica?
Ropiza.
You see Jose over there?
I do.
How do you know him?
That's my cousin.
Did you know Jose in Bridgeport, Connecticut?
I did.
Tell us about the family circumstances there in Bridgeport at that time.
We lived in a rough neighborhood. We stayed pretty close. We were, really family orientated. Jose was like my big brother. He still is. He always made sure that he, did positive things and told us positive stuff.
You would characterize him as a positive influence on you and the others?
Good role model.
The neighborhood was rough. Can you expand on that a little bit for us, please?
We lived where there was drug dealers, people who was always fighting, crazy people around us. We always stayed united as family. We try not to be around stuff like that, try to do good stuff.
But you could not avoid seeing it.
No.
And Jose would have seen it also.
Yeah.
Based on the answers thus far, may we assume that you and Jose and the family did not have a lot of money?
No. We had what we needed.
You mentioned the closeness of the family. Do you still stay close to Jose?
I do. Not as much as when we were younger, but I do. We talk. I visit. He visits us. We moved down here for 5 years, me and my sister.
Oh,
When
so
we
you-
were
you- from
when we were
Connecticut?
younger, yeah. After Jose moved down here, then we moved down with our father, and we stayed down here for about 5 years and came back. Well, we kept
And
in
you would
contact.
interact regularly with Jose while you were in Florida?
Not every day, but yeah, we did.
Have you ever seen or heard of Jose doing anything violent?
No, Jose was never violent. He was always cool, calm, collective, always giving us advice, make sure we don't fight, we're not doing wrong things.
But you do know what he is convicted of now here in this case.
I respect the jury's, decision. I don't know him to be that person at all.
Has Jose, within your observation and direct knowledge, exhibited kindness or generosity, anything like that?
He's always kind. He's always happy, positive.
Well, these are the folks who are going to be making a recommendation to the judge as to what should happen, whether Jose should serve out his life in a prison or whether he should be taken out and executed. Is there anything about Jose's character, anything about Jose that these jurors should consider when they figure that issue out?
Jose's really good-hearted, positive. He was never mean. He didn't like confrontation. He's just family kid. Made sure his siblings, his little cousins were good. They weren't getting in trouble. He never wanted that for us, ever.
That's all I have for you, ma'am. Thank you so much.
Thank you.
No question.
Thank you, ma'am. You may step down from the witness stand. And the defense next witness or item of evidence.
Your Honor, our next witness, and I believe our final witness, will be Carmen Escalera. Carmen Escalera.
And this witness will be testifying through the...
Yes, we'll need our interpreter. Yes, sir.
Members of the jury, the next witness is going to be testifying through Ms. Valdivieso. If you recall, she's been sworn for this trial to do her job. She's a court-certified interpreter. She does not need to be resworn. She works for the court. She's independent. Bear that in mind. She's completely neutral. She's here solely to assist in communicating the witness to you. She will repeat only what is said and will not add, omit, or summarize anything. And with regard to what she tells you, some of you may know Spanish, but it's important that all jurors consider the same evidence. Therefore, you must accept the English translation that she gives you and disregard any different meaning that may occur to you. Sure, if that's better, whichever is more comfortable.
Do you swear or affirm
Usted jura o afirma
that the evidence you're about to give
que el testimonio que va a dar
will be the
yes,
truth,
será la verdad,
the whole truth,
yes, toda la verdad,
and nothing
yes,
but the truth?
y nada más que la verdad? Yes.
Thank you.
Gracias.
Yeah, that would be fine. Judge, would it be easier to avoid the step up? Could we have the witness just sit right here?
Just concerned about the microphone amplifying her voice.
We would have one right in front here.
If that works, we can give it a try. Do we have the stand alone microphone? We give that to Ms. Valdez, so she can speak into that microphone. It'll amplify what she translates. Ms. Valdez, if you could hold that so the jury can hear your translation. It's not really matter. It's not important so much that they hear her amplified. It's more important to hear you.
Okay.
Is it on? You want to check just by? Very good.
Okay, ma'am. Tell these folks who you are.
Bien, señora, dígale a estos señores aquí quién es usted.
Me llamo Carmen Escalera.
My name is Carmen Escalera.
Okay. You see Jose there.
¿Usted ve a José allá?
How do you know him?
¿Cómo es que lo conoce?
Yo conozco eso.
Perdón.
Yo conozco que es mi hijo.
I know him because he is my son.
Okay. You remember when I came to visit you?
¿Usted recuerda cuando le fui a visitar en Connecticut?
Sí, yo me recuerdo, pero no recuerdo el día.
Yes, I remember that, but I don't remember the day.
Oh, you don't have to remember the exact day.
No tiene que recordar el día.
But I took some items away with me from you, right?
Yeah.
Yo tomé algunas cosas conmigo.
Yeah, pictures.
Yes, pictures.
So we'll get to them. We'll get to them first, okay?
Hablaremos de ello primero.
So I'm going to. May I approach the witness, Judge?
You may.
¿Me puedo sacar la
I'm going to show you some items, some photos.
Le voy a mostrar algunas fotos.
It is Defense Penalty Phase Exhibit 3.
Es el pruebas número, a ser admitidas número 3 del panel de la defensa.
Just hold them and take a look
Si
at
usted
them.
puede tomarlas y mirarlas.
Take a look through each one.
Mire cada una. This is me.
Oh, you don't have to. I'm going to ask you about them after you just.
No,
look.
no, le voy a preguntar en un momento. Solamente deseo que las mire a ver si las reconoce.
Have you looked through them?
¿Las revisó todas? Yes.
Por favor.
Do these photographs accurately represent these items that I have right here?
Estas fotografías aquí describen exactamente lo que yo tomé aquí. Yes, all of them, just like it is.
Okay, Judge, at this time, I would like to move the photo composite defense penalty phase 3 into evidence.
No objection. Those items will come into evidence without objection.
Thank you. And Judge, I would like to, I'm going to review the items one at a time with the witness. The photos will go back in evidence, but I'd like to publish the actual items if I might.
Any objection to that? Do you know what he's referring to?
No objection.
Okay, you may do so.
Yeah, I'll hand the actual photos
Sure.
around.
You
They
may
will
do
not
so.
go back. Yes, they will. The photos, this will stay with you,
Estas fotos se quedan con usted.
okay?
¿Está bien?
The rest. The rest.
The rest
The photo.
of the pictures.
All of it goes to you.
Todas se les va a devolver.
Okay, the jury will work with the photos.
El jurado se quedará con estas fotos, pero usted recibirá los marcos.
So let's work at them one at a time, okay?
Entonces hablemos de una a la vez, ¿está bien?
This photograph, what is this a picture of?
Esta fotografía, ¿quién está en esa foto?
My son, no my son, my sobrino. Mi sobrino.
That's my nephew.
And who is this?
¿Y quién está allí? That's me.
That's you.
Ese es usted.
All that hair.
Con
Yeah.
todo ese cabello.
Yeah, now that I
Okay.
No, it's gone.
Okay. We'll collect the money then. Do you recognize this item?
¿Usted reconoce este objeto? José.
That's Jose.
Ese es José. That's José.
Do you know how old Jose is?
¿Usted sabe qué edad tiene allí?
allí fuimos
¿Perdón?
un añito tenía.
1 year old.
Do you recognize this photograph?
¿Reconoce esta
My
foto?
grandson, that's it.
My grandson.
Son,
Hábleme en español, señora.
esos son mis nietos.
Those are my
Los hijos de
grandchildren. José's sons.
Jose's son.
Los hijos de José.
Who's
Yes.
who?
¿Cuál es cuál?
Daniel y el otro. El nombre se me olvidó.
También, and the other one, I don't remember the name.
Was this picture taken a long time ago?
Esta
It's a long
foto
time,
fue
it's
hace
bastante
mucho
viejo,
tiempo.
sí.
Yeah, it's a very old picture.
Thank you.
Gracias.
This photograph, this Jose too?
¿Y esta
Yes.
foto es José también? Yes, also José.
Was this a school photo or did you take it yourself?
Esta fue una foto, señora, espéreme. ¿Esta foto fue tomada por usted o en la escuela?
No, eso fue school.
That's from school.
Thank you. Do you remember what grade Jose was in there?
¿Recuerda en qué año estaba?
Kindergarten.
Kindergarten.
Oh, not in kindergarten anymore, I don't think. Who is this?
¿Y este quién es?
My son and his friend.
My son and his friend.
That's Jose?
¿Él
Yeah,
es José? That's
He
José.
was younger. Younger.
¿Perdón?
Sí, está jovencito aquí.
He's young in there.
Do you
Mira
remember
todo lo que tengo aquí.
All the pictures that I have here around him.
the young lady? Do you know who that is?
¿La jovencita sabe quién es?
Nancy, something like that.
¿Perdón?
Nancy. algo
I
así.
think Nancy, something like that.
Do you remember about how old was Jose when this photograph was taken?
¿Usted recuerda qué edad tenía José cuando tomaron esa foto?
He was 12 or 13 years old in that photo.
He was 12 or 13 years old in that picture.
14.
Or 14.
Was this photograph taken in your house?
¿Esa foto la tomaron en la casa de usted?
Sí.
Yes.
Thank you.
Gracias.
Who are we looking at here?
Y aquí estamos mirando acá.
grandchild.
My grandchildren.
These Jose's children?
Los
Yes,
hijos de
and this
José.
one, yeah.
Yes.
Okay, we've got 5 photos. They look like they're taken. Were these taken at the same time?
Acá hay 5 fotos. Fueron las 5 fotos tomadas a la misma vez.
Mira, sí.
Yes.
Hace.
Yes.
Una casa.
Yes, the same place, the same house. I ordered them.
Aquí mayor, entonces José.
That's my
This is
daughter,
Jose?
and that's Jose.
Yeah.
This is
That's
Jose
his sister.
and his
His sister.
sister.
Yes.
Did you have a photographer come to the house to do this?
Yeah.
Un fotógrafo vino a la casa. Yes.
How old do you remember Jose is there?
¿Qué edad recuerda usted que tenía José allí?
Ella tiene como, él tiene entre 2 años
He's about 2.
y ella entre 1.
She's about 1.
Thank you.
Yes.
Okay, this is the last item.
Este es el último objeto.
What is this?
¿Qué es esto?
Un diploma de la escuela de José.
That was a school diploma from Jose.
And the date is 1982, is that right?
El año es 1982. ¿Es eso correcto? Yes.
And,
This is there.
and it says that that's Jose's name there?
¿Y está el nombre de José allí?
Escalera.
Yes,
And
José
this
Escalera.
diploma says that in 1982, Jose Escalera is entitled to promotion from kindergarten to first grade.
Acá dice que José Escalera en el 98 entonces pasó de kindergarten a primer año. Yes, to first grade.
And that's given at Bridgeport.
Y eso se hizo en Bridgeport. Yes. Gracias.
Tell me about when you and Jose were living in Bridgeport and Jose was growing up in Bridgeport. Was it a tough neighborhood or a nice neighborhood?
Cuéntame cuando usted y José vivían allí, cuando él estaba creciendo en Bridgeport. ¿Era un barrio difícil o era un barrio bueno? It was a good one.
How long did you live there?
¿Cuánto tiempo vivió allí?
20 años ahí.
Over 20 years there.
And in this good neighborhood, did you have a lot of money, ma'am?
¿Y en este barrio tenía usted mucho dinero?
¿Dónde? No.
Money from where?
Can you, remembering Jose when he was in school or when he was with that young lady, remembering Jose's essential nature, would you describe Jose as a violent person?
¿Usted recuerda cuando José en esa foto de jovencito con esa amiga, usted recuerda cuál era la naturaleza de su personalidad, que si él era un muchacho violento?
No.
No.
Él era amable.
He was kind.
Had you ever seen him to hit anybody or be involved in fighting?
¿Usted alguna vez lo vio a él pegarle a alguien o estar involucrado en alguna pelea?
Una persona que yo sé, yo puede que estar mirando, pero no lo vayan a golpear.
No, he was one that I have to defend, so nobody will be hitting him.
Oh, he had to be defended himself.
¿Que tenía que defenderse?
Él solo no, no entiendo cada problema.
No, he never asked for trouble.
How did he do in school?
¿Cómo le iba en la escuela? Very well.
Did he go all the way through and get a high school diploma?
No.
¿Terminó la escuela y sacó su diploma de high school? No, no.
Did he move to Florida when he was a teenager?
Él se mudó a Florida cuando era un adolescente. Yes.
And did he work and make his own way when he came to Florida?
Él trabajó y se mantenía él mismo aquí cuando se mudó a Florida.
Sí, salimos solos.
He was working all by himself.
You mentioned that Jose was kind.
Usted dijo que José era amable.
Sí.
Yes.
Was he the type to become hot-headed and angry?
Él era el tipo de que se le calentaba la cabeza y se enojaba. No, not at all.
Did you observe him, or would you characterize Jose as being a positive influence on his cousins?
Usted lo veía a José como que él era una influencia positiva a sus primos.
No,
¿Perdón?
no.
No.
No, he was not a good influence. Was he a
No,
bad
no,
influence?
era buena
Él
influencia.
no era, él no le hacía nada a mí ni nada, era de eso que quería, era de, no,
¿Perdón?
no de eso, él no, no sé. Que no, no era mala influencia para las nenas. No,
He was not bad influence to the children.
He was not a bad influence.
No era mala influencia.
no.
No.
Was he a good influence?
Él era buena influencia. Yes.
Have you been able to stay in communication with Jose while he's been in jail here?
Yes.
Mientras él estaba aquí en la cárcel, ¿usted ha estado en comunicación con él? Yes. By phone.
Have you been able to put any money into the jail so Jose could buy snacks or stuff like that?
¿Usted ha podido poner dinero en la cuenta de él para que él pueda comprar cosas de comer? Yes. Yes.
Do you know whether Jose provided support for his children, financial support?
¿Usted sabe si es que José mantenía económicamente a sus hijos?
Él mantenía así.
He supported them.
Is there anything else about Jose's nature or character that you would like these folks here to think about when they make their decision?
¿Hay algo que usted desea decir de la naturaleza o de la personalidad de José aquí a estas personas para que ellos tengan en cuenta cuando tomen su decisión?
Bueno, con respeto les digo a ellos.
With all due respect,
Esa decisión de él.
that is his decision.
Thank you. That's all the questions I have for you, ma'am. Thank you for coming.
Gracias, esas son todas las preguntas que tengo. Gracias por estar presente.
Any questions from the state?
¿La fiscalía desea preguntar? No hay preguntas.
Thank you. You may step down from the witness stand.
Usted puede retirarse, señora. Ahí la van a ayudar.
Members of the jury, we are about to conclude the case with the arguments by the attorneys. Before we do, the evidence is closed. However, I do want to instruct you that the parties agree or stipulate that the defendant in this case has no significant history of prior criminal activity. So the lawyers are about to argue the case to you. As I mentioned, the evidence is closed. What the attorneys say is not evidence, but do listen closely to their arguments. They are meant to persuade you in your evaluation of the evidence and influence your decision from their perspective. Both sides will have an opportunity to make an argument to you, but the state is allowed to proceed first, and the state may proceed with its closing argument.
Think back again, all the way back to jury selection these many weeks ago, right? And we had talked about our ability to keep our word and follow the law, right? That's what we're here for. That's what we're here to do. We remind you again at the last closing argument, and I'm going to keep beating that drum, right? Because it's so important to be able to follow the law and to keep our word, particularly in a case such as this with the evidence that's been before you. When you do that, always, always view this evidence through the lens of objectivity, and to make sure that we render a dispassionate verdict, right? You've been confronted with highly emotional evidence from both sides, right? And that's why it's important to view this evidence as dispassionately and as methodically as we can so that we arrive at the correct decision. Emotional people make bad decisions, right? Emotional people make bad decisions. That's why we've got to look at this evidence with objectivity, reason, and logic, right? So, having said that, this is what we're confronted with today. And again, I'm going to kind of go through this process again. I know we've heard it before, but we want to make sure that we get it right. So, to be clear, you are confronted with not one death sentence, but two, right? 2 death sentences are on the table, 1 per count. Count 1 deals with the murder of Tania, count 2 with the murder of Josiah. Each count is analyzed separately, and we use the same process that's been set forth in the jury instructions that was detailed to you by Judge Murray. Of course, the first step is we got to have a unanimous finding that the state proved at least 1 or more aggravating factors per count in order to proceed with the death penalty. Those have to be proven beyond a reasonable doubt, right? And in this case, both counts share the same 3 aggravating factors, the same 3, and then there's an additional aggravating factor for count 2 that deals with Josiah. So here they are. The first one, the defendant was contemporaneously convicted of another capital felony, right? Contemporaneously or at the same time. The murder was committed for financial gain. There's your second aggravator. The first-degree murder was committed in a cold, calculated, and premeditated manner without pretense of moral or legal justification. Right? Those are our 3 aggravators that are shared by both counts. Count 2, in which Josiah is the identified victim. And this one is this. The victim of the first-degree murder was under the age of 12. That's it. That's it. And so we'll start with the easiest one first, right? The first aggravator, this should be unanimous, is this one. The victim of the first-degree murder was a person less than the age of 12. Well, what's our evidence to support that? Well, of course, it's straightforward, right? We first, Tania was pregnant. She was very far along into her pregnancy. We presented the testimony of Dr. Stossel, and what did Dr. Stossel say? Do you remember? He said, listen, this was a perfectly healthy child. This was a perfectly healthy child. Mom had some complications, and mom was high risk, but that child was perfectly healthy. So there's your unanimous aggravator, at least for count 2. Then we go through the remaining aggravators and that apply to each count. So the first one, the defendant was contemporaneously convicted of another capital felony. Well, that's what we have here. This aggravator applies to each count because the homicides occurred at the same time, contemporaneous, at the same time. The count 2 would be an aggravator for count 1, and vice versa. Count 1 would be an aggravator for count 2. So this has already been proven, and it's reflected in your first verdict. Next, the first-degree murder was committed for financial gain. Okay, let's talk about this. So in the transcript, session 3 of 39, you heard the evidence. This is the words of the defendant. She's pregnant from that little a-hole that works there. She says it's mine, supposedly. I can't take any chances. I lose everything. I'm going to blow her brains out so that she doesn't talk. I have to do it, Eric. I have no other choice. And then key sentence, I am going to lose everything. I am going to lose everything. And then he follows that up. If my wife found something like that out, oh my God, bro, I lose everything, bro. So there is our aggravator. So how do we arrive at financial gain from those particular circumstances or from those particular statements? I'm going to lose everything. We all know what the consequences are of a possible divorce, right? That's what he's looking at in his mind. He's looking at a possible divorce. So what does that mean when he says, I'm going to lose everything? Well, first off, as we all know, just from common human experience, what happens? You get a divorce, your cost of living increase, you no longer have a second income. Remember, his wife is working with him at WastePro, right? His wife works with him at WastePro at the time of this, right? So we have that. And we also have, what do we have? Child support, right? This is his way out of paying child support. Now, it's important to keep in mind, this financial gain, it doesn't have to be the primary motive for this killing. Let me be very clear about that. This does not have to be the primary motive for this killing. It can be a motive for this killing. And that's the state's position in this case. It is a motive, not necessarily the primary motive. And it's borne out by this defendant's own statements. It's borne out by his own statements. I'm going to lose everything. That means his wife. That means financial, his ability to prosper financially. That means he can avoid child support. That's what that means. And that's the aggravator in that particular case. Next one. And the most significant, right? The capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Okay, here we go. Remember, and the jury instructions define it. What happens is it defines each subpart, right? Cold, calculated, premeditated. I'm going to walk you through each one of them. Cold, this is what the jury instructions say. It means the murder was the product of cool and calm reflection, right? Cool and calm reflection. What's our evidence that supports that definition? Well, here it is. 2 days prior to the murder. The murder happened on August 23rd of 2018. This statement was made on August 21st of 2018. Listen and think about what he says here. I just can't do it inside my truck. It won't hurt me if it's not my truck. I got to strangle that bee. You can't leave no blood or nothing in the truck. I don't want nothing, nothing, nothing. If they ever come asking about anything, there's nothing. It's like you said, there's no other way around it. It's like you said, you got two unintelligible and that's it. All the BS will be over, and the higher up around here, the more they'll blame her boyfriend. Because they're always fighting, you know what I'm saying? She now has a record in which someone did something to her. You know what I'm saying, all that S. So think about what he's talking about here. He's already developed a plan as to how he's going to kill her. He's already developed a plan as to how he's going to execute. I said her, it's both of them, right? As to how he's going to execute both of them. This is his plan, and he's smart enough to know I can't do it inside my truck, right? Because he's trying to figure out a way to not leave blood. I got to strangle that bee, right? So he's coming up and he's developing this plan, and it's with an eye towards avoiding detection, right? He's minimizing his risk. He's trying to get away with this, right? So I can't leave no blood. Of course, the best laid plans of mice and men, right? He did leave blood in the truck. He did leave blood in the truck. But 2 days beforehand, his plan is to get away with a double homicide. So think about what he's saying here. And the higher up around here, presumably he means law enforcement. The more they'll blame her boyfriend, right? The more they'll blame her boyfriend because they're always fighting. You know what I'm saying? She has a record in which someone did something to her, meaning that the law enforcement will look and find out cases in which she's been a past victim, and then they'll point the finger at him, right? Think about that. So not only has he developed a plan to execute Tania and Josiah, but his plan is more in depth than that. His plan is more devious than that. What does he do? He is attempting to frame this so that someone else can be blamed for the murder, right? Someone else, an innocent person, can be blamed for these murders. That was his plan. That was his plan, not only to execute these people, but to get away with it. And third, to make sure an innocent person was convicted in his stead. Extreme facts call for an extreme sentence. Extreme facts call for an extreme sentence. Was all of this, the questions before you is, was all of this, is that the product of cool and calm reflection? Absolutely it was. Absolutely it was. Calculated. Calculated means having a careful plan or prearranged design to commit murder. Okay, so what are our facts that support that particular sub-element? Well, again, 2 days prior to the murders, He's in this Waste Pro truck and they're driving around with Eric Alvarado, and what does he say? You can't prove anything if no one saw anything. I was thinking of taking her to some field nearby the route. Adolfo Cavelli testified the scene of the crime was on his trash route, right? So his plan, he was able to execute his plan, right? So he took her to a place near the trash route. Do you know where I go? When she go in there, she disappears for a couple of days. She does that. She disappears for 2 or 3 days. She always does that. And I'll take her phone and I'll throw it away. I'll throw it away or I'll burn it. They can't do anything there. I have everything planned out. This was not, ladies and gentlemen, a homicide or homicides that was committed in at the spur of the moment, in heat of passion, when someone's upset, when somebody wasn't thinking through the consequences of his actions. Oh no, he admitted, he stated, he had everything planned out. Extreme facts call for an extreme punishment. And premeditated. The third sub-element. Remember, this is exactly what you've already found. This portion of the jury instructions, it's no different than what you found during the guilt phase. It defines premeditation. What is added on in this phase is this particular section right here. For this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. So that's the difference. That's the difference for the aggravator. The aggravator adds on this requirement of demonstrated by a substantial period of reflection. So what we have is we've already gone through statements where he's made 2 days in advance about how he's planned it out, right? 2 days in advance he's planned it out. But do you remember, think back to Kenneth Barron during the guilt phase, right? Kenneth Barron was the guy, he comes in and he says, listen, this defendant approached me about a ghost gun, right? He approached me about a ghost gun. And when did he do it? 2 to 4 weeks before, right? 2 to 4 weeks before. If he's to be believed, and we have no reason to disbelieve him, is there enough evidence to support the proposition that the defendant was thinking about this murder and planning it out and premeditating it out 2 to 4 weeks before it happened? Of course there is. Of course there is. What Kenneth Barron said fits in with all of the other facts and all of the other evidence that was gleaned in the state's case, right? Is there any reason to disbelieve Kenneth Barron? All of this evidence, all of it shows that the state has been able to establish this particular aggravator beyond a reasonable doubt. And then the final sub-element is this. It was carried out without any pretense of moral or legal justification, and then it defines that as any claim of justification or excuse, though insufficient to reduce the degree of murder, rebuts the cold, calculated, premeditated nature of the murder. Okay, so have you been presented with any evidence that would either justify or excuse these homicides? No. No. There's no question that we have proven this aggravator beyond a reasonable doubt. And so remember, then we get to the mitigating evidence, right? Then we get to the mitigating evidence. And let's take a fair look at it and figure out where to go from here. And remember, as we all discussed in jury selection, we consider everything, right? Everything we consider. But then after we consider it, what do? We figure out how much weight it deserves, right? So that's what the law says. The most impactful mitigator certainly is the fact that this defendant has no significant criminal history. You obviously consider that and obviously give it whatever weight that you believe it deserves It's up to you to decide how much value this mitigator has after you weigh it against the aggravators, right? So it's weighed against it. The first, I think it was the first witness that was presented yesterday was Raul Benasco. He was the fellow who testified via Zoom. He's your prison expert, and he worked with the Department of Corrections. I think he's in Texas now. And he came in, and if I understood him correctly, the gist of his testimony was, well, okay, we get it. The defendant will adjust well to prison life, and he's going to be able to follow all the rules and not become a problem. So that's what you're being asked to believe, okay? Well, let's think about that. Let's consider that for a second. If I understood Benasco's testimony correctly, he met with the defendant for an hour and a half, right? He talked to the defendant, someone who is facing the death penalty, and he talked to him for an hour and a half. He then reviewed the defendant's behavioral records from the St. Lucie County Jail, right? And based on that, he arrives at the conclusion that he will not be a problem in prison. Okay. Even if he were to be able to accurately predict that, and there's no guarantee that he can. After all, he's going to go to prison, right? If there is ever an unpredictable environment in this world, it would be prison, right? You're not talking about a bunch of rule followers in prison. They're there for a reason. So let's assume that let's just, for argument's sake, let's be fair. For argument's sake, let's assume that he can accurately predict that, right? Let's assume that he's accurate in that. How much weight do you give that, right? How much weight would you honestly assign that when you're looking at the aggravating evidence in this case? How much weight would that be? Would that honestly give and fairly give when you view this evidence objectively? When you view it objectively, how much weight would you give that? The answer is very little, very little. So then we get to Lucinda Cook. Lucinda Cook is the ex-girlfriend. She says that she was in a relationship with him between 2006 and 2012. She didn't have a meaningful conversation with this defendant for 13 years, right? That was her testimony. She has not spoken to him in a meaningful way for 13 years until just a few weeks ago. I think her testimony was a month ago I spoke to him. So either during the jury selection process or right before the jury selection process, the defendant re-enters her life, right? The defendant re-enters her life. Okay, again, and she also said, well, he was never violent with me. Okay, he was never violent with her. Okay. So again, the question is, and only you can answer this, is how much weight would you assign that? Right? How much weight would you honestly assign that? Somebody who hasn't spoken to him in 13 years, how much weight do we give that evidence? Very little. Very little. And then, of course, today you have the defendant's mother and his other family members. Okay, again, highly emotional testimony, as you would expect, right? And of course, they're going to have good things to say about him, as you would expect, right? No surprise, as you would expect. His mother is going to come in and say nice things about her son in these horrific, horrific circumstances. So, my question would be, how much weight would you give that, right? I mean, if we're here to give our reasoned judgment and weigh the facts and the evidence out and apply it to the law in as dispassionate a way as we possibly can, right? We're not here to be swayed by our emotions. Emotional people make bad decisions. if we weigh this out and as dispassionately as we possibly can, would we give this testimony any weight? I think you give it minimal weight. At best, you give it minimal weight. And of course, we finally arrive at the weighing process, right? And again, this is directly from the jury instructions that we spoke about at length during jury selection. And it's very, very straightforward, very, very simple. You know, whether sufficient aggravating factors exist, which of course they do, and then whether the proven aggravating factors outweigh the proven mitigating factors. That's it. That's all you do. So I end with this. You know, our criminal justice system relies on accountability, right? Our criminal justice system demands accountability. And part of that is to punish people proportionate to the crimes that they've committed. Punish them proportionate to the crimes that they have committed. This defendant, he murdered Tania and Josiah Wise for no other reason than he believed that he would lose everything if his wife found out about the pregnancy. He could have come clean to his wife. He could have paid child support. He could have been accountable to his wife. But he didn't do that. He planned this murder out for a lengthy period of time. And he executed that plan. That's what he did. That's what you found. Extreme facts call for an extreme sentences. That's what we're here for today. Ladies and gentlemen, this defendant deserves not one, but 2 death sentences. Extreme facts call for extreme sentence. That's what I'm asking you to impose today. I'm asking you to impose a unanimous vote on both counts for the death sentence in each count. On behalf of Tom Backethoff, your state attorney, on behalf of the people of the state of Florida, I thank you for your patience and your service this month. Thank you very much. It is, I speak for everybody, it is truly appreciated on everybody's part. Thank you so much. Thank you.
Mr. Richardson, in the defense argument. Mr. Burns.
Yes, thank you, Your Honor.
Thank you.
Greetings also to you. Tania Wise. Josiah Wise. Murdered by Jose, who is my client. The trial is always about the accused, but the case is about those two. The main facts of the case are that they are not here anymore. And I tell you that because it's true. And I tell you that because I wish you to recognize that I know it. None of the evidence that has come before you has been received by me in any inhuman or different way than you have received it. I've just lived with it for a much longer time. I wish to respond to some of the things that Prosecutor Richardson just indicated. He made a very strong case, and I told you yesterday that I am not going to quarrel with the fact that this was a coldly and calculatedly and premeditatedly done act. We have Jose's voice in his truck a couple of days before this. That was his plan. I don't dispute that. So what does that mean for you? Well, it means you're going to unanimously find that there is an aggravator. And the gate is swinging wide open for you to kill him if you want to now. Last legal requirement is met. The baby, I told you yesterday, that those photos look to me much like a newborn baby. certainly less than 12 years of age. I don't argue that aggravator. Now there are two. I'm here to try to save my guy's life, not insult your intelligence. Those two factors are there. I don't have arguments against them that are in any way meaningful. That the crimes were committed while there were contemporaneous other capital felonies going on. Jose kills Tanya, the baby, is a contemporaneous crime. They work back and forth as aggravators. If you wish to find them so unanimously, I will only say this: the existence of the baby Josiah, the fact that Tanya was pregnant, is clearly a central fact. But Jose's intent, while it would necessarily have to cover the baby, his anger, his hatred, whatever it was that was really pushing him and motivating him along, was aimed at Tanya. There were no abdominal injuries. No indication of hatred toward the baby. Mr. Richardson tells you that because Jose said I'd lose everything, that therefore, beyond a reasonable doubt, you should all conclude that this crime was done for or affected by financial gain. No, that is not proved. If you are worrying about losing your marriage, that doesn't mean you're worried because there might be financial implications. If you're worried about losing your job because your wife is a supervisor, the uncontroverted evidence before you is that Jose has worked steadily since he's 15 and been totally self-sufficient. A divorce is not going to knock him off kilter. Fearing having to look for a new job is not going to prompt him to do a murder. That this crime was done for financial gain is not proved beyond a reasonable doubt, because of the consequences of divorce, because of child support. He paid child support for 3 children, is the evidence before you, and gave groceries and clothing for the 4th. That is not proved. Extreme facts require, says the state, an extreme sentence. These are horrible facts. Every murder is comprised of horrible facts and would consist of photos of a victim in sight, photos of a victim during autopsy. Jose, according to the evidence, planned to get Tanya to a place and kill her. That's every mob hit ever. Let's get Paulie to the club and we'll whack him. That's not an extreme fact. That's an ordinary fact. We're talking about facts of murder, mind you. We're talking about murder. To get someone to a place where no one can see to do the crime is not extreme. It's common in murder. Raul Benasco spent 90 minutes with Jose. Perhaps Mr. Richardson would prefer that he moved in with him for a year in his cell. How long is a man supposed to sit with them to learn some history and review his prison record, which is what the man's expertise is all about? That Lucinda Cook had no communication with Jose for 13 years and yet came in here after all that time to speak on his behalf doesn't count against him, it counts for him. What kind of an impression did he make on her? That after all this time she consults, she prays, and she comes in. When other people are jumping ship, she comes in. And her intention is not to tell you who he is now or quarrel with you about your verdict. It's to say, look, whatever you found that he did, I'm surprised by it because that's not the way he behaved with me and with my children. With us, he made us feel safe. And that takes me to kind of one of the topics that I want to discuss with you. I had hoped to just roll through here without having to refer to anything written, but the situation changed with my witnesses and whatnot, and so I'm going to refer to some topics here, and then I'm going to explain them to you. And one of the things that's going on here I'm going to refer to as box and balloon. Box and balloon, it sounds like a kid's game. Bear with me here. The box is the life of Jose Soto-Escalera. In toto, everything. From birth to now, certainly from birth to the time he did the murder. And as you heard from his family, yeah, it's what's expected from family. Would your family come in and run you under the bus? I hope not. So, he was good. He was generous. He was uplifting. He was a mediator. He left and encouraged us to come out. There were good things to Jose. He comes to Florida. There are women who say good things about him. Madeline Colon and Lucinda Cook. He has long-term relationships with them. He supports emotionally and otherwise children that are his and that aren't his. He brings safety to women who are recovering from traumatic relationships. All that is in the box. At the bottom, we insert a balloon. The balloon is this crime. It is this murder. It inflates because it is the chief act within all the acts of that box. The question for you is, how big does the balloon get? Does it crowd out every other thing in a man's existence to the point where you regard him as almost inhuman and therefore like a cigarette butt or a cockroach? He's not. He's a horrible, horrible killer. And other things too. One of the topics I have written down here is humility. Humility. I recommend humility to myself. I don't always follow. I recommend humility to most people in most circumstances, and I most absolutely recommend it to you here in thinking about this. Why do I say this? Because you made an impression on me. When I sat back while Ms. Minton did all the work early in the case, I was watching and I was listening and I was very, very impressed with your confidence. How confidently you all said, this one I'd kill him, I'd kill him, I'd kill him, this one, I don't know. You're very confident in your ability to make these judgments, and I wonder, in addition to being impressed, I say, how do these people come by this confidence? Do you have education? Do you have experience in this regard? You were on the streets a couple of weeks ago, now you're in here deciding who lives and who dies. That's correct according to the law. And it's probably good that we don't leave it up to just one person. But I still think you ought to think about how perfectly suited you are to do this. Take a look. Think. How do you think? When's the last time or when was the first time any of you thought about how you think? Probably not. It's a thing you do. You put on your shoes, you make a bowl of cereal, you think. You're thinking all day. Your mind's taking you here and there. How exactly does it work? When have you examined the functioning of your brain? Look to that door right there. Let's use our imaginations. These folks here are essentially asking you to put a target on Jose's back and make arrangements for death to do his thing with this guy, because the law permits you to do it and you would decide that's what should be done. So through that door now comes death. Death is coming in, coming through the gate. Death is right here. I'm asking you to imagine death is right here in the room with us. How many of you perceive death right here in the room with us as a female? None of you, right? As a child, none of you, right? He was some hulking, some version of the Grim Reaper, right? You have conclusions and ways and things in your brain and you don't even know how they got in there. Death could be a woman. Death could be a child. It could be a noxious cloud. But you, I'm pretty sure, had death as a male. In what other ways do you think or make decisions and you're not even exactly sure why? This is intended to be an abiding decision. Live with you forever. Like your religion, like you love your children, like your sports team, things you don't change. And so if you decide to kill Jose, that means that you are right now, today, knowing how you're going to think forever, right now you're going to lock your brain into an unyielding rigidity that says, kill him. And if someone asks you next year, or in 10 years, or in 20 years, oh yeah, I'm still good with it. That's what it means. And that's why I say you should approach this with some humility. I want you to imagine something else. I'm going to call it a spectrum of death. Jose is on it. Over here is one end. And I'm at this end, and you're at this end, and everyone else in this room is at this end because we had no involvement with killing. You ever killed anyone? Never thought about it? And certainly didn't engineer it and make a heavy-duty recommendation that it be done. We are all over here, unstained and unsullied by any association with death and killing. Jose is on the spectrum here. Jose is on the spectrum. Let's make this mark on the spectrum where we started with Ashley Minton's questions to you. In the next courtroom over, we've got a murderer, a first-degree murderer who intended to do it. Now, we have a little more than that. We have some aggravators. So Jose's a little further on the spectrum of death. Way out here at the other end of the spectrum of death is we'll put our state actors, your Hitlers, your Stalins, people who killed in the millions. It's not really relevant to us, but it's out there because what you need to comprehend, and I don't know if it's ever come through in all the system, in all the sessions that we had, how do we decide what is a death penalty case? The people that you send to Tallahassee, when they become geniuses and philosopher kings, they look at the spectrum of murder, all of it, and say, okay, where are we going to pin it to say what is a death penalty case? And so, the whole circumstance that we've found ourselves in, since the first group came in here on September 2nd, is we are wallowing around in death and talking about death, and the first thing we do before we have a trial is talk about the death penalty. And you're a jury of Jose's peers. But as you know, from your individual groups, a lot of your peers didn't like the death penalty, but they're on the outside of the door now. So what I'm looking at is a box full of, I won't say killers, but people who are comfortable with it. You all said many, many times, oh yeah. Up and down the road, will you invoke death? Yeah, I'll do. Yes. You're the same people who just convicted him. And I'm just one guy with some words. And I'm afraid you kind of roll right through me and try and kill him, but you don't have to. Here's one simple thing. And in thinking about this argument and then making it, I kept coming back to it because I'm a very simple person, possibly a simpleton. And it is this: why would any ordinary, decent person with a conscience orchestrate a death if they don't have to? Why would you make someone die if it's not required? And it is not required under any circumstances that you have heard or will hear. If Jose is to die judicially, it's because you did it. You want it to be done. The judge can't do it on his own. You have to do it. And so you, I'll use the word contort, but maybe your brains flip right into that position naturally. I say you have to contort yourself and everything you believe and your conscience is to get to a place where you can say, I'm morally comfortable with killing a guy. Let me talk about some of the mitigators. Where's my list of mitigators? There are a lot of mitigators. There are always a lot of mitigators because anything can be a mitigator. And I'm behind the 8 ball. So I'm going to throw a lot of mitigators out there. I don't suggest they're all of equal weight. I don't even consider them all of equal weight. But I don't know which one you back there might latch on to. So I'm going to run through them quick. I might highlight a couple of them. This list will be attached to the instructions. It will be part of the instructions that the judge will read you, so you don't have to remember it. There are 29 of them, and some of them strike the same theme, but if Jose was nice to 4 people, I'm gonna name them all individually. As you have heard, as the judge has told you, there's no dispute that Jose has no significant history of prior criminality. That I will highlight for a moment, because that is an extraordinary fact. Do you recognize that? This is a convicted double murderer who did nothing prior. And I think that's important, and I suggest you should think that's important, because if I'm going to make a heavy recommendation that a judge kill someone, it should be a bad person. It should be a very bad person. It should be a pretty bad person through and through. That's not who Jose is. This is an explosion of violence that comes out of nowhere in his life. It doesn't make it any better. Still makes it a murder, but it doesn't make him the type of utterly useless human who you might want to put down. He's not utterly useless. And this is not in keeping with anything that he has exhibited before. And that is very important. Jose was abandoned by his father as a child, raised in chronic poverty. I'm going to stop on that one for a minute, because we did discuss that many times, and a lot of people in jury selection didn't like it. And remember, we're past the guilt phase. No one is saying, poor Jose, you let him go because he grew up in poverty. But poverty brings challenges. That's all I ask you to recognize. You know, we acknowledge the importance of 2-parent homes and sufficient money to meet our needs, and yet if people don't have that, we really don't cut them any slack about it. All I'm saying is consider it as a mitigating factor. He had less than probably you and many others. I don't know exactly what that means. My dad was a school teacher. Jose suffers from transgenerational family trauma. There's problems with the mama, problems with him, problems growing up in Bridgeport with no money. Chronic exposure to trauma during his childhood. The mama seems to remember the house being fine and the neighborhood fine, but it was not fine. You heard from the cousins, this is not a fine neighborhood. It was a violent neighborhood where drugs were dealt on the streets, and crime was in the streets, and crime was seen. And that's not an ordinary way to grow up. Jose can positively contribute to society in prison as a worker. I don't contend that that is an especially weighty concern, but it is a totally relevant concern, because remember, where is it? It's life without parole. Look at that. It's like the forgotten option somewhere. Well, I'm blowing the dust off it, and it looks pretty good. It looks fine to me. Life without parole. Let's remember, and I will recall to you what you told us also at the same time, within probably 2 seconds of telling us you all can impose the death penalty, you all said you would consider life without possibility of parole. And if you're sitting here now not doing it, you're not following the law and you're not doing your job. If you decided last week he's guilty and you're going to kill him, you're working a charade and a fraud on us right now. So everybody's mind better be open. You don't have to like what I'm telling you, but you got to listen to it. And you told us you would consider it. And I'm not exactly striking the tone of a beggar here, but nevertheless, you have a job to do, and I'm going to make sure that you do it. Jose has established and maintains long-term substantive meaningful relationships with friends. Jose has established close family bonds and relationships with his cousins. You know penalties have consequences that ripple. You're going to kill someone. You know that. You heard from the victims in the case. Jose has maintained a close relationship with his mother, maintains close family bonds with his children. You know, that's supposed to be the motive here. And yet he's had opportunity galore and never killed anyone. That doesn't mean he didn't do this, he did. But if he is monstrously wrong for killing one child, you can't deny him or deny the existence of the fact that he helped and contributed and lived a meaningful part of his other children's lives for a long time. I don't know if there's a rug back in the jury room, but you would not be doing right to pick up the corner of it and sweep facts you don't like under it. Jose demonstrated exemplary jail behavior. He poses no danger to prison staff or inmates. Again, these are all relevant considerations if he is going to be living for years before execution and living out the rest of his life in prison. How he will do in prison is completely relevant for you to consider. Jose has been a positive influence on family members. Jose will be required to work 40, 60 hours a week. That's every day in DOC. As a prisoner, you know, Jose's a prisoner. He's been a prisoner for 7 years. When you capture prisoners in war, you don't kill them. It's a war crime. But here, it's okay to kill prisoners. Think about that. You're being asked to kill a prisoner. He's neutered. He's nothing. He's been in handcuffs and shackles behind bars in a secure jail, guarded 24/7 for more than 7 years. What is the need to kill him? You got that much of an urge? Take him out of his cage and put him down? He's helpless. He's hopeless. That's enough. Your common sense should tell you, your understanding of the world, at least the United States, should tell you that there's plenty of states that don't have a death penalty at all. And they might say, well, he's a prisoner. Well, you got to kill him. You kill prisoners. That's where your morality is. You kill prisoners. Who's more helpless than the prisoner? Jose was a positive influence on his former girlfriends and their children. Jose can be redeemed. For that matter, you know what Jose did 7 years ago. Do you know where his head is at now? If he's taken out in several years and executed, you kill the body, but what is his head? Where will his mind be at, do you know? Will he be the same person? Because that's how punishment works, of course. Who among us hasn't suddenly snatched up one of our children, put him over our knee, administered a spanking, and said, that's for what you did 7 months ago? It's not how punishment should work. Jose provides support for his children. No prior history of violence, no criminality, no violence. He has helped his former girlfriend and his son's mother escape dangerous domestic violence situations. He has always been a hard worker in manual labor fields, furniture delivery, security work, others. Jose escaped a high-crime, high-poverty area independently, moving to Florida when he was just 15 years old, and he made it on his own. Despite lacking the opportunity to complete his education, he overcame that lack of education through consistent work ethic. He never took a dime of public money, even though he was just a teenager. And again, that undercuts the argument that he did this killing in any way connected to or for or about pecuniary or financial gain. He's always had to work and always had money. Jose has exhibited excellent courtroom behavior. You probably know that people accused of crimes, especially murderers, especially in long trials and processes, they don't always keep their mouths shut and they don't always behave. Jose has behaved just as he has behaved as an inmate. Jose will continue to offer positive life influence on his children, family members, and friends who have become emotionally dependent on him. He began working and earning money to help support his family at a young age. He's always been self-supporting, as I mentioned, not a drain on society. Some, if not all of those, you should find exist a little more likely than not, and then you are required to consider them. What weight you give them is completely up to you. This part of the process seemed to confuse a lot of your fellow people who didn't make it onto the jury, who kept insisting that the law, they're just going to follow the law. The law is depositing you off here at a crossroads if you don't realize it yet, okay? You are going to tell the law what will happen here. Life, forever and ever, until you die and they take you out of prison, or death penalty. And the law doesn't tell you which one. But the law does tell you that life without possibility of parole, like the stepchild option in here, is not a stepchild option. It's perfectly good. The law gives you a choice because it's perfectly happy with the life. Perfectly happy. And so should you be. It would keep you off the spectrum of death. If you do order and recommend that Jose be killed, you're not outside over here off the spectrum of death. You move a little bit closer to him. You now have some involvement in killing. Not that you'll do it yourself. You'll just set the first domino falling that will result in it. Jurors isolated from the execution. You're making a moral decision, but you're not making it in a vacuum, and don't think because it will happen years down the line and you won't be there and the needle won't be in your hand that you're not responsible. That's my point to you. You are responsible. The prison's far away. You're still responsible if it happens. Well, someone else in the state's employ, the state executioner, will do it, so your hands will be dirty, but it's your handiwork that will be done. So don't think of it as just, you making a death recommendation is like dropping some instructions off on your secretary's desk as you leave for a long weekend. It is not that. Victim impact statements. We heard from several members of Tanya's family. Her mother, I suggest, especially, and her son, who I thought testified very impressively for his mother. And it may not matter coming from me, but I'm quite certain his mother is proud of him and would be proud of him. But I hate victim impact statements, not for the reason you probably think. Because in fact, I love victim impact statements done right. Victims should have a voice. They should be heard, especially in crimes of violence and especially in loss of life cases. I think victim impact statements should be published in the newspaper and court administration should pay for it. They should have a voice. But here, in this process, that voice is best expressed to the judge with experience, not to the jurors with none. Because within this tight process that you're following that might lead to someone's death, in comes these victim impact statements, and where do they fit into the process? They do not. What will the judge tell you? Well, the purpose is to establish the uniqueness of the victim and the impact on the family and community. Who would dispute that a murder victim is unique? Everyone in here. We're all the same and all exactly different. Of course Tania Wise is unique and special and has special characteristics and qualities. But the only thing that you're instructed to do is not regard it as an aggravator. Well, what are you hearing it for then? It for sure ain't no mitigator. Every single one of those statements is like an emotion bomb, a sympathy grenade going off, bespattering the walls with sympathy. Not for my guy. In fact, it is so much seeming like an aggravator that you have to be told it's not an aggravator. So that's one thing I don't like about it, that it's dropped in here unfairly. It operates against me and my client, but what am I supposed to do with it? What are you supposed to do with it? It's not an aggravator, and you're only supposed to be deciding the case on aggravators and mitigators, so what are you supposed to do with it? And the other reason I don't like it is because it lends itself to being a victim ranking system. If Tania Wise had no family whatsoever to come in here for her and give victim impact statements, is her life and her murder any less important thereby? No. If Tania Wise was the chief of surgery at the local hospital and saved hundreds of lives through her surgical skills, would that make a difference? It should not. One man, one vote, one murder victim, all the same. They're all the same. Every life is valued the same. No life is valued more than another. If Tania had nobody to come, if that whole segment was not here at all, okay, it's victim impact time. No one to say here. So what are you supposed to do? She must not be worth very much. Right? Or, look, it's 100 people come in, she must be worth so much. It's a victim ranking system, it stinks. Everyone's the same. No one deserves to be killed, no matter who you are. And so I don't like it for that reason. Look, this case is loaded with emotion from top to bottom. And that's just a gigantic injection of it, and for what? I'm not sure what you're supposed to do with it, and you can't be sure either, because it doesn't fit in. It's not an aggravator or a mitigator. That's what we're doing here. We're weighing aggravators and mitigators. We're figuring out factors of his character that might lead you to not kill him. That Tania is unique, that her family is mourning, that there's a void that won't be filled. Yes. But that's not the point. The point is that she is a person who should be alive and is not now, due to Jose's criminality. Who she is important, but it's important outside of this process. Here's another one of my little topics that I wrote. This is not a fixable situation. You know that. Tanya's gone for 7 years now. Josiah never had a chance. Never began. Whether he is imprisoned, Jose, for the rest of his life, or whether he gets taken out at some point and injected to death, whatever they put in there, Tania and Josiah will not come back. It can't be made right. And we, you, me, that doesn't, it just doesn't fit right. And I think it especially doesn't fit right for Americans, because we don't, okay, what are we going to do about it? Let's do something. There's nothing meaningful that can be done. If there are people rooting for the death of Jose, I don't know that there are. If that day comes, they may experience a moment or a day of satisfaction, but I think the next day after, the heaviness and the sadness of the loss is still there. It's undiminished. That's the fact. He lives or dies is less important than the loss that cannot be made right. Killing him won't fix it. It won't fix it. It won't take the pain away. Let's talk about something that we mentioned in jury selection, Which, by the way, does it seem that Ms. Minton, that poor Ashley did so much of the work here in this case and I did relatively so little? That's my fault. Here's a little inside baseball for you. This is my case. I am lead attorney in the case, and Ms. Minton works for me, so to speak, under my supervision. And I could have done everything, or I could have done nothing. But like I told you yesterday, I waited a long time for my chance to speak to you. And the detectives among you have already figured out, because I knew I would be here. I knew there would be a penalty phase. And I figured that this would be the hottest part of the trial for Mr. Jose Soto-Escalera. And so I figured that this ought to be my post of duty and not Miss Ashley's post of duty. But everything that has transpired in this courtroom has been done with my knowledge and my approval from the defense side of things. And you know what? You know why? Maybe you're thinking, well, hey, Attorney Burns, what'd you drag us through a trial for if you figured your guy was guilty already? Because they're trying to kill my guy, and they're going to cross every T and dot every I before they get to do that. Late in a losing game, a losing effort, the final seconds click off the clock. The quarterback doesn't drop back in the pocket and take a knee and give up. He heaves the ball as far as he can and hopes for a miracle. Do you think you are the only ones who can read and understand and appreciate and see evidence and what it means? I've been doing this for a long time. Whatever you can do in that regard, I can do better. I knew I would be here. And we make no apologies for fighting every step of the way, including now. And frankly, I feel like I'm in the last ditch, maybe fighting you all off when I got nothing but a rusty sword in my hand, a slingshot, nothing but words. And I really don't want you to kill my guy. But we're going to talk now about mercy. I hear some of your voices. I hear them from here saying, oh, counselor. Attorney Burns, I was kind of half with you, sort of paying attention up to this point. But mercy for this guy? Mercy. You may, if you hearken back just a few weeks, you will recall when Miss Ashley was addressing this topic with you. The point that was attempted to be made, and the distinction to be made, is how does mercy work? Does the guy who gets it have to earn it? People who give it just give it? The concept, I believe, that was attempted to be taught to you, and there's not really much time in that classroom where you have to address 20 other matters, is that mercy is always in the power of the victor. Weak people, losers, don't get to grant mercy. People who have power get to grant mercy. And so, whether it's withheld or granted has very little to do with the recipient and very much to do with you, the grantors. It's a statement of who you are. And so, if any of you are still even within earshot on this issue of mercy, you need to just consult yourself and say, look, am I a merciful person or not? What does mercy mean in this case? The merciful thing is to condemn Jose to live for decades and decades and decades in prison behind bars until he dies. To become institutionalized and infantilized over time and be told when to go to bed and when lights on and lights out and when to eat and not to eat and look through bars and never get out. If I imprison you guys in your old high schools, how long would it be before you went crazy? He'll be in a prison. That's, most people would not consider that a merciful result, but that's what mercy means here. So it's not a great big fat dollop of mercy go forth, Jose, it's a little drop of mercy that says, I'm going to kill you. That's all the mercy that would be requested here. Let me take you back a couple of days, and I'm going to read you some words that Judge Merman read to you in describing the elements of first-degree murder. And then I'm going to make an argument from that by reworking those words a little bit. None of what I say to you is a legal instruction. It's just an argument. It's just food for thought. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. That's what the judge read to you. Now I'm going to change it up a little bit. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind of each juror at the time of engineering the killing. The law does not fix the exact period of time that must pass between...
Improper argument. You don't approach.
You may continue.
What I'm saying to you is the process that you are relying on. This is a moral decision that you make as individuals. And it should be based on a system that you understand and that you can follow. I am going to talk about what you've been asked to do last week and what you're asked to do now. And I'm going to do a compare and contrast. At no point am I suggesting that anything you do or might do is illegal. I am not asking that anything you do or not do is in any way related to you being murderers or illegal killers or equating you in any moral way with Jose. But you were asked last week to convict a man because he thought about doing a killing beforehand and did it. What are you being asked to do?
Objection, again, improper argument. The difference is
I'll complete the thought and I'll rule on the objection if there is one.
The process that is before you, if you follow the instructions and carry it out and think about it, means that you're thinking about forming the intention to ask the judge, recommend the judge to kill Jose. So in this circumstance, it's righteous, right? So sometimes thinking real hard about doing a killing is okay, if you're comfortable with that. If you should go back there and 8 or more of you decide independently, and by the way, this is an independent thing. I don't say you can't talk to one another or nothing like that. But so far you have kind of walked the path together. Jury selection, you get on the jury, you hear the evidence, you've made your decision, and now all of you stand here at the point together. But you sort of come up the stem or the base of a Y, and now you're at the V part and you're looking at the crossroads. That's where the law has deposited you now. And I have acknowledged that the state has demonstrated that there are aggravators. And as I told you, the gate is open for you to kill. And I recommended humility. I recommend you don't go down that path. I wonder, with that gate open, I don't actually think so, looking at you, but if any of you might, now or in 5 minutes or 10 minutes, regard it as some sort of a temptation. No one gets to be in your position, very few people, to say, live or die. Look at, here he is, live or die, it's up to you. It might be tempting. Walk the path that people don't get to walk. It's a forbidden path, highly forbidden. But it's open to you. If you should find it alluring or tempting in any way, the forbidden fruit of control over someone's life or death, you're not in the Garden of Eden being tempted, you're in the Valley of Death being tempted. Walk out of it, go away, take the other path. Do not do any killing that is not absolutely required, and this is not required ever. Sometimes large matters can be understood in simple ways, in things that might happen all of a sudden. And you don't even know it until it happens. And one of those, I'm going to hang with me here if you can on this example, is I've called it lean in, lean out. Lean in, lean out. People, they lean in, they like something. Lean out when they don't. Lean in to give that first kiss. Hopefully someone's leaning back. Maybe they're not. Maybe they get to lean back. Never happened to me, of course. But I use the example in this way. If you are a juror who votes to impose the death penalty, and you should remember, this is an abiding decision. You're good with it now, you're good with it tomorrow, you're good with it forever. You should end up in conversation with someone, the topic comes up. And what did you do? I voted to kill him. Whoa. You're going to get the whoa. You're not going to get the what? And the person hasn't even had a chance to think about it. It hasn't penetrated to the consciousness of that hearer at all. But you're going to get this, you're going to get a drawback and a whoa because you just admitted to them that you're on the spectrum. You're on the killing spectrum. You're not over here, the rest of us having nothing to do with it. You just said, yeah, I set a man up to die. And that doesn't get a, that gets a, think about that. This is a big decision. Yeah, I'm just about done. I'm running out of juice. When you go home this afternoon, after having come back and given us your decision, you will now be a life giver or a life taker. You're not going to be the same. If you vote to set the wheels in motion, to give a heavy recommendation to this judge to kill this man, you're not going to be the same. This is a life taker. You are not. Leave the life taker alone on the spectrum of death. Don't take a step nearer to him. You don't have to. I invite you in my final words to consult your best selves, the highest portions of your consciences, the lightness in your heart, not the darkness in your heart. To rot and die in prison is not merciful. It is a horrible, horrible sentence. Do that to him. Thank you.
Thank you, attorneys. Members of the jury, I'm about to instruct you before you deliberate. The instructions, just as in the guilt phase, are in writing, and a copy for each of you will go back into the jury room during deliberations for your further reference should you need it. However, do pay close attention to the instructions I'm about to give you. And for those of you who are in the audience, the instructions will only take about 10 minutes. You must stay for the entire instructions so as to not distract the jury as they pay close attention to these instructions. Members of the jury, you have heard all the evidence and argument of counsel. Now you must decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must not consider any other facts as an aggravating factor other than what has been alleged and proven by the state beyond a reasonable doubt. The aggravating factors alleged by the state applicable to each victim are: 1. The defendant was previously or contemporaneously convicted of another capital felony. The crimes of first-degree murder and first-degree murder of an unborn child are capital felonies. 2. The first-degree murder was committed for financial gain. And 3. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The term cold means the murder was the product of calm and cool reflection. The term calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. The aggravating factor alleged by the state that applies only to the unborn child is the victim of the first-degree murder was a person less than 12 years of age. You have heard evidence about the impact of this murder on the family, friends, or community of Tania Wise and her unborn child. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Tania Wise's death and that of her unborn child. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each alleged aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find each aggravating factor has been proven beyond a reasonable doubt. And the verdict form itself is in conformity with that. As to each of the counts, there's a section for you to do just that, and it will be self-explanatory when you see it. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstances exist. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exists. Mitigating circumstances need not be proven beyond a reasonable doubt. Instead, the defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You need not reach a unanimous decision about whether the defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: 1. Jose Soto-Escalera has no significant history of prior criminal activity, and 2. The existence of any other factors in Jose Soto-Escalera's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. A list is attached hereto to these instructions for your convenience regarding the defendant's proposed mitigating circumstances alluded to by his attorney. That is, the list is behind your instructions as Mr. Burns argued them. The final step in the process is for the jury to determine whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all of the following factors. 1, whether sufficient aggravating factors exist. And 2, whether the proven aggravating factor or factors outweigh the proven mitigating circumstances. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty, the court must sentence the defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation is for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight and deference to your recommendation. You will be provided a form to reflect your decisions, which is a verdict form. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your decisions. That concludes the instructions, and at this time, the jury, with the exception of our 4 alternates who now at this stage know who they are, that Ms. Emmert, here, the remainder may proceed to the jury room, and if the alternates have items in the jury room, the ballots will retrieve them. The jury should proceed to the jury room to consider its verdict. All right, the jury has exited this time. Ladies, this actually does conclude completely your service in the case. I want to reiterate what I told you, whenever that was. When was that? Last week, some point, that you know what the purpose was for you in this case. If someone had fell ill or had some other circumstance that required them not to be here or did not permit them to be here, you would have taken their place. And alternate jurors are so important to us because of the gravity of this case and how long it's been around and how long it takes to try it. For that reason, we had 4 alternates, which is probably a record for me. Normally I have 2 or 3 at most, but we went with 4 just because we wanted to be sure that we would conclude this case. So that's why we had 4 of you. And we got lucky. We didn't lose any jurors. But the whole point of me explaining that to you is to sincerely express on behalf of everyone here how appreciative we are of your time, which is an extremely significant amount of time. I hope you found the experience rewarding and educational at a minimum. I always feel a degree of guilt on my own behalf because you were alternates that didn't serve, but it does conclude your service. I do want to advise you of a very special privilege that you have. Even though you are not involved in the deliberation process in deciding the guilt phase or this part, you still have a privilege not to speak to anyone should you wish. No one can compel you to speak about the case other than by court order. And you should realize that in a case of this magnitude, with so much attention paid to it, people may be curious or they may seek to find fault with the process. Realize that before you decide whether to exercise your privilege not to speak about the case. But you are allowed to speak about the case. That's the whole point of that. The rules governing your conduct no longer exist. You're free from all of that. But you're free with my thanks on behalf of the United States and the state of Florida. Thank you so much, ladies. You are free to leave at this time. The bailiffs will assist you. All right, the jury is entering. All right, Ms. Bickley, the foreperson of the jury, if you would please hand the jury's decision to the bailiff for my consideration.
Shall we remain standing at this table?
Yes, please, actually. Let me review the verdict form. You may be seated at this time. The verdict form is in proper form. The clerk shall publish the verdict omitting the caption.
As to the murder of Tania Wise, we the jury find as follows. As to the defendant Jose Soto-Escalera, aggravated factors. We the jury unanimously find that the state has established beyond a reasonable doubt that Jose Soto-Escalera was previously temporarily convicted of another capital felony. Yes. We the jury unanimously find that the state has established beyond a reasonable doubt that the murder of Tania Wise was committed for financial gain. No. We the jury unanimously find that the state has established beyond a reasonable doubt that the murder of Tania Wise committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. If you, the jury, answer no to every aggravated factor listed, you have completed your deliberation as to count one. We, the jury, find by a vote of 8-4 that Jose Soto-Escalera should be sentenced to death for the murder of Tania Wise. Verdict as to the murder of the unborn child of Tania Wise. Aggravated factors. We, the jury, unanimously find that the state has established beyond a reasonable doubt that Jose Soto-Escalera was previously contemporaneously convicted of another capital felony. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the murder of the unborn child of Tania Wise was committed for financial gain. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the murder of the unborn child of Tania Wise was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the unborn child of Tania Wise was a person less than 12 years of age. Yes. If you, the jury, answer no to every aggravated factor listed, you have completed your deliberation. We, the jury, find by a vote of 8-4 that Jose Soto-Escalera should be sentenced to death for the murder of the unborn child of Tania Wise, dated this 25th day of September 2025. Foreperson, Aria Bickley.
Please be seated. I will poll the jury this time. Ms. Busa, does the decision announced by the clerk accurately reflect the jury's decision?
Yes.
Ms. Sedano, does the decision announced by the clerk accurately reflect the jury's decision?
Yes.
Ms. Robinson, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Miss Edwards, does the decision announced by the clerk accurately reflect the jury's decision? Miss Johnson, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Miss decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Miss Mr. Fleischer, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Miss decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Miss decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Mr. Does the decision announced by the clerk accurately reflect the jury's decision?
Mrs. Yes, Your Honor.
Ms. Holmes. Mr. Majak, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
And finally, Ms. Does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Thank you. Ladies and gentlemen of the jury, the decision of the jury is accepted by the court subject to further proceedings. It does conclude your service in this case. Before I release you, I want to instruct you of a very special privilege enjoyed by jurors, and that is no juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For centuries, our society has relied upon juries for consideration of difficult cases, and we have recognized for hundreds of years that your deliberations, discussions, and votes should remain your private affair as long as you wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although at this time you are at liberty to speak with anyone about the case or your deliberations, you are also at liberty to refuse to speak to anyone, especially in a case of this nature, of this magnitude, in a high-profile case. A request to discuss either your verdict or your deliberations may come from those who are simply curious or from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere, and it will be left up to you to decide whether to preserve your privacy as a juror. Especially given your incredible time commitment and patience that you've had in this case. Before I release you, I want to thank you so much for your time and commitment to this case. On behalf of the flags behind me, the United States of America, the state of Florida, thank you for your service. At this time, it's complete, and at this time, the ballots will assist you in leaving the courthouse. Thank you. All right. At this time, the defendant, of course, remains remanded in the custody of the sheriff pending further proceedings in this case. You maybe all be seated. With regard to the Spencer hearing and the sentencing, I have proposed timeline with some dates that are subject to the attorney's convenience and approval. For the Spencer hearing, I have the week of October 6th with Monday, Tuesday, Wednesday, and Friday, which is October 6th, 7th, 8th, and 10th at 1:30 as possible times. And then my intent would be after the Spencer hearing on one of those dates at 1:30, the sentencing would be in early November, November 3rd, 4th, 5th, or 6th, which is Monday through Thursday at 9 o'clock in the morning. Did you all want to consult with your calendars and tell me what you think would be better for you?
Ms. Minden will answer for the defense.
Sure.
I'll go through it anytime.
From the state?
I'm good for any day on the Spencer hearing. My request, I have a date certain trial on November 3rd in Indian River County, the week of. Does the court have any dates available after that week?
Let's see. If you just need to be in trial, Mr. Cormier could be here just for the sentence pronouncement, because there'd be no attorney involvement in that. So I really would not want to go later than that. I could go earlier than that, too. It's possible to go earlier than that, but that might be somewhat problematic. The reason I don't want to go earlier or later than that is, of course, my retirement is coming up. And as you know, as I mentioned, cannot work on this case whatsoever come the end of the year. So there may be some proceedings or administrative matters for me, depending on what the ultimate decision is in that time frame. So, and then when you say date certain in our business, you know, really date certain or not really? You know, date certain subject to last minute requests for continuance, so forth. But
Well, Judge Meadows set it for a date certain back in like June or July. And I've spoken to the public defender. It looks like we're both going to be ready. Of course, anything can happen.
and that's as far as the actual sentencing goes, that's really secondary because that could be adjusted. The first matter is to have the Spencer hearing. That's the most important aspect of this. You're looking at your calendar, Ms. Minton.
October 6th is good for me, Judge.
October 6th, 1:30?
Yes, sir.
Does that work?
Yes, sir.
All right, so let's go with October 6th at 1:30. And my suggestion regarding that would be depending on what your request is, you could either get your arguments orally or in writing or both. If you are going to do them in writing, it might be better to get them to me a bit earlier than that, just so I can ponder them before I, come to court if I have questions. But either way is fine. There's really no set procedure there. Also gives you the opportunity to present further evidence by the defense at that time. All right, anything else for us to address at this time until we come back on the Spencer hearing?
No, sir.
Can I ask Mr. Richardson? Mr. Richardson, do you want to address count 3 and 4?
There's 2 remaining second-degree murders from a previous information that was filed. The state will not somehow process both of those.
Okay. All right, we'll see you then October 6th, Monday at 1:30 for the Spencer hearing.
Yes, sir.
Thank you.
Thank you.
All right, so court will be adjourned until that time. That'll conclude our proceeding for today. Oh, they should get that from the clerk. Yeah. Is no one down there?
They asked if you could just type something up saying that they were here and sign it so we can give it to their employer.
How many jurors?
11 of the 12.
11 of the 12?
Take one and I'll copy it.
There's no one from the jury clerk office to give them that? Because that normally comes from the jury clerk.